Nick Carnes on behalf of the people.
Robert Hartzell for Ms. Jones. You can come over here.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old and then had the gall to post another video of it on TikTok.
I covered the case of Estrella Rose Jones back in June on CourtShorts. So far, 1.2 million people have watched it. You don't need to, because that hearing and 2 others, including a new one with a new charge and a new rejected plea, are in this special video. For those who don't know, CourtShorts is my other channel. I don't typically overlap cases, but this shining Estrella is so special that she gets her very own supercut. I've left the link to CourtShorts in the description. You should check it out. Every video is one hearing, and they're all 5 minutes or less. Estrella keeps beating people up and blaming it on her meds, what someone said about someone else's deceased mama, and her headphones, among other things. And now Judge Wiggins can't take her plea on the new case because of complications. One thing is for certain, Estrella appears in court a lot more respectfully in an orange jumpsuit than she does in a white tube top. Let's roll, nerds.
This is case number 251740SM. Appearances, counsel?
Nick Carnes on behalf of the people.
Robert Hartzell for Ms. Jones. You can come over here.
We are set for a pretrial conference. It appears we have a resolution in this matter, Mr. Carnes.
Yes, Your Honor. It's my understanding the defendant will be pleading no contest as charged. The people are supporting a delay of sentence with a full dismissal if the defendant is successful on the delay. Success on the delay would be whatever programming is recommended by probation and no violations of typical probation conditions.
Is that a Killebrew?
Yes.
Okay.
And the reason for the no contest plea is potential civil liability, Your Honor.
And so just so we're clear, the success was completion of programming and no violations.
Correct, Your Honor.
Mr. Hartzell?
That is accurate, Your Honor.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in a place of confinement. Now, along with that, there's what's called a Killebrew agreement. And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case would be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you were going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yeah.
And is that how you wish to proceed?
Yes.
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
Council, I've been provided with a Cadillac Police Department report, incident number 250000819. It's been marked as People's Exhibit number 1. Mr. Carnes, do you move for its submission?
Yes, Your Honor.
Mr. Hartel?
Yes, Your Honor.
No objection then. The People's Exhibit number 1 is received. Give me just a moment to review that. Okay, we are back on the record. I've had the opportunity to review the People's Exhibit number 1. Do council believe that it forms a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by the old, what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac and is between Haynes Street and River or Wright Street on the what's now known as something along the lines of the green trail or the green pathway. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should a case of civil liability arise, although I question what the civil liability would be since there's no injuries, but I guess that's not for me to determine. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's no contest, especially for civil liability, I'm cautious to overly allocute for obvious reasons. But what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients if they don't do well, there is the risk of jail later, the loss of the delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working at Qdoba. She's aware she owes some money on some older files, but she is going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the guilty. Thank you.
Carnes?
Thank you, Your Honor. This is a disturbing incident involving a defendant and a 14-year-old. Clearly shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I'd ask the court to place Ms. Jones on a delay of sentence up to 8
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that on me, and I am familiar with Ms. Jones on some other things, but not where she was the defendant. So if the court has
well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Was there charges on that?
She was 18. That was resolved with a civil infraction, I believe. I'm just going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that. But I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Alts, because I had a conflict on that because I was the elected prosecutor when that was arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept under the rug. All right, court calls the people of the state of Michigan versus Estrella Rose Jones, case number 251740 SM. Appearances, counsel?
Nate Carnes on behalf of the people.
Robert Hartel for Ms. Jones, who joins me at the table, Your Honor.
And we are here for a continuation of a plea and sentence from last week to a plea of no contest to assault and battery with a killabrew for a delay and a dismissal. We had adjourned for the parties to brief the issue to convince the court to follow the killabrew agreement. Today, I received from the defender's office a mitigation report, and I've not received anything from the prosecutor's office. Is that correct?
That is correct, Your Honor.
All right. And Mr. Carnes, we addressed this in chambers before we came in, but any reference to HIDA in your mitigation report should be to a delay of sentence. Is that correct?
Yes, I apologize for that type of.
Okay. So I know we already did allocution, but because of procedurally where we're at, Mr. Carnes?
Your Honor, we do have the victim's father is here today and would like to make a statement.
All right. What is it you would like the court to know?
I would just like, mostly for Australia, to know that, you know, they could have all of them handled differently. You don't learn to take things through, get used to this. That's it.
Had you been, you understand what the plea agreement is in this case?
Yeah. I think they kind of explained it to me.
So what the agreement is, and the court hasn't said it's going to go along with it yet, but what the agreement is that she would plead to the assault and battery. She would be placed on a delay of sentence for up to a year. And during that period of time, she'd be on probation. If she were successful with the probation, the charge would be dismissed. If she's not successful, the charge would stand. Do I have that correct, Mr. or Counsel?
Yes, Your Honor.
Do you have any thoughts on that, Mr. Whaley?
I think it's a good idea.
How is your daughter doing?
She's doing good. I mean, it affected her, you know, but
How so did it affect her?
just being out, walking around town. She didn't deserve that. She got it happened, and she'll get through it.
Okay. Anything else you'd like me to know?
No.
Okay. Thank you for coming today. You can go back out. Elocution, Mr. Hartel?
Yes, thank you, Your Honor. I do I thank the victim's father for being here today and his statements. I do recall watching the body cams as part of my due diligence, and that says similar things to law enforcement, and it rings true. I know this is a no contest for civil liability, so I'm going to do my best to resist my instincts to overstep a little bit with my elocution, but I do believe that my client does not want to find herself back in the situation again. I do believe it would be in the best interest of society to allow this to occur, not only for her own benefit, but I do believe for society as well, because then she can be a better member of society. She's young, the opportunity of having a carrot and a stick for her to be able to keep her record clean if she does everything right, to be as productive a member of society as possible. And although I don't want to over paraphrase what the victim's father was saying, I do believe he seems supportive of the idea of her learning her lesson from this.
Mr. Hartel?
Thank you, Your Honor. The one thought that came to mind throughout this case was the saying that hurt people. I do recall a case where Ms. Jones was a victim of felonious assault. And then it's unfortunate to see her as the perpetrator in this case. My hope with this plea offer, would be that she could be rehabilitated to break that cycle. I did note in the mitigation report, the page 3 under recommendation states Estrella is not a threat to public safety. Estrella can be a threat to public safety. That's clear through this. I sincerely hope she no longer is. I do think probation programming under a delay of sentence with impulse control, anger management, something that I trust the probation department to fashion could help to ensure that she's not back here for this sort of thing in the future. I would ask the court to go along with the Killebrew agreement here for a delay of sentence. Thank you.
Thank you. Ms. Jones, you have the right to address the court before sentencing. Is there anything you'd like me to know?
I'm very sorry. I never intended to hurt her. I was trying to work like that. And I even myself was very shocked seeing the video. And I'd love to get into.
You'd love to what? I'm sorry?
The anger management classes and more help.
Well, I know you've been through a lot, and I'm familiar in the various roles I've had of the different issues that you've had. And the struggles that you still continue to face. Are you still employed? And now that you're back on your medications, have things kind of leveled out for you?
It's coming.
And are things going good at your job? The mitigation report describes your peers as saying that they consistently describe you as caring, reliable, and helpful. That certainly wasn't you this particular day, at least as I read in the report. And I don't want you to make a comment on that. But one thing that the court has to do is it has to balance the interests of justice in one, doing the best that we can for you, but also while protecting society and making sure that we're keeping society safe. Do you understand my concern with putting you on a period of probation that's going to basically allow you to erase your record? Do you understand that concern I have?
Yeah. I understand.
And again, without any comment because of the no contest plea, at least the way the report describes, you went after this girl pretty hard. And it sounds like she had some effect from that based on what her father said. And so I have to sit here and decide, is that a conviction based on the actions that I have found you've done by reading the police report? is that something that I think protects society by allowing that to stay on your record. And those are the struggles that I, as a judge, have to face. And I know when we were here last time, we had discussed, that you essentially had no prior history, but it wasn't because you hadn't been in trouble. It's just things had been resolved differently. And as I said before, the law is designed to recognize that young people in certain situations do stupid things. Not that I find that this was excusable by any means, or that this was a stupid thing. This was you physically attacking a 14-year-old girl for a comment that was made about somebody else's mother, deceased mother. And then if I recall correctly, there's quote unquote round 2 video for TikTok. I understand there's maybe some reasons for your activity, being off medication and et cetera. But, as Mr. Carnes indicated, you yourself were a victim of a felonious assault. And if I remember correctly, Mr. Carnes was at the gun being pulled on her.
Yes, sir.
And then you turn around and assault a person who's 5 years younger than you. And you're an adult. She's 14 years old. But at the same time, I realize that you have a struggle aside from this that you need to overcome. And I don't necessarily want to saddle you with anything further. I am a firm believer in allowing people to shape their own destiny, so to speak. So if I do put you on this period of delay and follow the agreement, your fate is in your own hands. Do you understand that? It's entirely up to you as to whether or not this conviction stays on your record. If I do follow the agreement and you've done what you're supposed to do, it could be gone in a year. Well, I want to thank Mr. Hartel for having his staff write the mitigation report, because it does shed a little bit more light on everything that's going on. So that puts a little different light on things as to where we were last week when we were here. So I am going to follow the recommendation. I'm going to put you on a delay of sentence for 12 months. That's the longest period I have available to me. If you're not successful, the conviction stays. So during this 12 months, you're going to not violate any law. All right, court calls the people of the state of Michigan versus Estrella Rose Jones, case number 2532228FY. Appearances, counsel?
Joanna Carey for the people.
Nathan O'Meara on behalf of Ms. Jones.
Robert Hartel also helping with the jury trial.
And we are set for a preliminary examination. Is there any resolution in this matter?
Yes, sir.
And what is that?
My understanding is the defendant will plead guilty to aggravated assault. That in count 2, the people will dismiss count 1, felonious assault. She's agreeing to pay restitution in the amount of $100 to the city of Cadillac, separate misdemeanor case.
I don't think it will have my disqualification in that case. I don't think we'll have an issue with me taking that plea. The question is whether you want to waive it for me to simply sign the paperwork dismissing it when it's presented. Otherwise, you'll have to wait for Judge Van Alt.
We totally fine with you doing it.
Okay. If you want to get signatures on that, then you need some time to talk with her about that, or have you already?
No, I mean, we talked about it a little bit.
Ms. Jones, before we get into the plea taking, have you had ample opportunity to discuss the conflict that I have with the case that Judge Van Alt is handling? Yes. So for whatever reason, I have a conflict with that case. My guess is it probably came up during the time I was the prosecutor, but I don't know that for certain. But by signing this form, you're agreeing to waive that conflict and allow me to handle that case. I'm sorry, I gotta take this call. So Ms. Jones, what I was saying is, for whatever reason, I have that conflict. And you do have the right to not waive the conflict and keep Judge Van Alst on that case. Or by signing this form, you agree to allow that conflict to be waived and allow me to sit as a judge on that case. Is that your understanding? No, it doesn't look like that you have signed this. It looks like counsel has signed it on your behalf. Was that your request? And are you hereby requesting that I act as the judge on that case?
Yes.
All right. And I will go ahead and sign this. We will remove it from Judge Van Alt's docket and place it on my docket. Now, Ms. Jones, have you heard what the attorneys have said the resolution is in this case, which is 253228FY, the felony that you're charged with, the felonious assault? Have you heard what the plea agreement is in that matter? So it's my understanding you will be pleading guilty to an added count of aggravated assault, which is a 1-year misdemeanor, which means I could put you in jail up to a year, and or fines of $1,000. There is also an agreement that the prosecutor, I say it's an agreement, that the prosecutor will recommend time served plus probation. Is that the agreement, Ms. Carey?
Yes.
Now, Ms. Jones, do you understand that that is your agreement with the prosecutor? I don't have to follow that agreement. If I decide that I'm not going to follow that agreement, you would be able to, no, let me back up, I'm sorry. That's not a sentence agreement, so that is just their recommendation. Their recommendation, their agreement with you is that they're going to recommend to me that it be time served and probation. I'm not required to follow that agreement. Do you understand that?
Yes.
And if I decide that I'm not going to follow that recommendation, you have no recourse. It's not like before where you would be able to withdraw your plea. You don't have that option here. Do you understand that?
Yes.
It's also my understanding that you're agreeing to pay $100 restitution to the city of Cadillac in file number 252342SM, which is the case we just removed from Judge Van Alt's docket.
Yes.
In exchange for all of that, the people will then dismiss that case in its entirety and the 4-year felony of felonious assault in the case that we're here for today. Is that your full understanding of the plea agreement? Have I missed anything?
I apologize.
I don't believe so.
All right. Ms. Carey, did I cover that?
I think so.
All right. Defense, have I covered that?
I believe so, Your Honor.
All right. And Ms. Jones, that's your full understanding of the plea agreement?
Yes.
And you wish to take advantage of that plea agreement?
Yes.
You please raise your right hand as best as you can. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
So we know back on July 12th of this year, you were on probation in another file, and we've already dealt with that violation or potential violation. Were you on bond in any other file?
No.
Do you remember reading and signing this advice of rights, talked about your rights to an attorney and your rights to a trial?
Yes.
Did you understand those rights?
Yes.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up the right to have a trial, and you won't have a trial of any kind?
Yes.
Ms. Jones, to the offense that on or about July 12th, 2025, in the city of Cadillac here in Wexford County, that you did commit the offense of aggravated assault, how do you plead?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on July 12th of this year?
Assaulted Austin.
And how did you assault him?
I was like, there's something at him.
Hold on. Do you know what you threw at him? Okay. Tell me how you came to throw something at him.
Scared of him because he's not the same person I know anymore. He's currently in the past and scared me, and I was in fear of my life. He said he was going to kill me.
Counsel, I can't accept the plea. Do you want some time to regroup?
Yes, Your Honor.
We'll take a recess. We are back on the record in 253228FY, the people of the state of Michigan versus Estrella Rose Jones. Counsel, where are we at?
if the court is willing, we'd like to attempt any one more time.
Ms. Carey, an objection to
No.
that? Ms. Jones, is that still your desire?
Yes.
And do you need me to go through the terms of the plea agreement again? I am going to go through these next questions with you, though. Other than the plea agreement, has anybody promised you anything?
No.
Has anybody threatened you?
No.
And is it your own free choice to plead?
Yes.
Are counsel still aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
Correct.
Or correct, yes.
All right. And then, so Ms. Jones, back on July 12th, 2025, in the city of Cadillac of Wexford County, to the added count of aggravated assault, how do you plead?
Guilty.
So what happened back on July 12th?
I used to live with Austin and he took my headphones and I threw something metal at him.
And why did you throw something metal at him?
Took my headphones and I was scared of him.
Why were you scared of him?
He's lost himself to drugs. And he's hurt me.
He's what?
He lost himself to drugs and he's hurt me before.
How has he hurt you before?
He used to beat me up over the last year now.
Over the last year, you said?
Yes,
And
I haven't talked to him in a while. So
when you went, was it his house you went to?
yes,
And you threw the object, do you know what object it was?
something metal.
Okay, where did you get the object from?
I believe his porch.
All right. And why did you throw it at him?
Because he took my headphones and was scared.
Had he done anything to you other than taking your headphones before you threw the object at him? What did he do?
He's hurt me.
Did he hurt you that day?
Yes.
How so?
He punched me.
And where were you at when he punched you?
On his porch.
Was it at that same time period?
Yes.
Okay. And how soon to you throwing the object at him was it that he punched you?
Don't try that. I was off my meds. It was blurred.
Was it a matter of seconds or an hour?
Second.
Okay. And just so I've got it right in my head, you confront him about the stolen headphones. He punches you when you throw a metal object at him.
Yep.
Do you know why he punched you?
No. My only assumption was the drugs.
Okay, but had you said anything to him?
I'm asking for the back.
Did you make any outward attempts to strike him first?
I don't believe so, no.
Did you threaten him in any way?
Don't remember, sorry.
And when you say you were on the porch, is it an enclosed porch or an open porch? Okay.
Like there's a wall, but there's no screens. The only way up it is the stairs, and off of it is the stairs.
Okay. How hard did he punch you?
I felt my face crack.
Where did he punch you at?
The temple to my nose.
So just for the record, you were pointing to your right temple down to your nose?
Yes, I tried to dodge it, but he still hit me.
Open or closed fist?
Close.
Counsel, I still don't believe that gets us there.
I
agree with that. I think we may not be able to accept the plea today. I apologize.
If that lipstick told me it was really deep and he had staples.
No, I understand that, but there's times when a self-defense is there, and at least with what's been presented with me today. I think it's possible that I'm not saying that there is a self-defense claim. I'm just saying there's enough of a question of whether or not it was a self-defense for me to accept a guilty plea today. It's nothing that you've done wrong. It's just there's that question there. There's nothing you have to apologize for. It's just the way it all plays out sometimes. So we were set for preliminary examination, but I note that the plea sheet was signed earlier. Ms. Carey, I'm assuming we're not prepared for prelim today?
Correct.
All right, we will go ahead and we will get this on the docket for next week for a prelim. If something happens that you're able to enter a plea before that, you can do that. Before we adjourn today, is there any other matter we need to discuss?
Yes, Your Honor, I'd like to address bond.
Any objection to that, Ms. Carey?
Your Honor, the plea agreement today obviously had a recommendation from the prosecution and from, or would have been concurred with myself for probation. Based on that, in a perspective, the plea wasn't accepted today. But I think that Ms. Jones has suffered quite a bit while in jail, and in a way that could be remedied by being on bond or being out on bond. She has mental health problems that she mentioned a little bit earlier that she would like to be able to address more properly and can address more properly with the support of her family outside. She's not a flight risk. She lives here. I have no fears that she wouldn't appear in court. I don't think, based on what the court has, or based on my knowledge, I don't think that any event like this is likely to happen again, especially while she's on bond. So I would ask for a personal recognizance bond. Thank you, Your Honor.
Thank you, Ms. Carey.
But I ask that you continue her current bond pending the preliminary exam in this matter. I don't have her full criminal history with me. As the court knows, she was on probation at this time. At the time that this occurred, she has a juvenile history. I don't have any knowledge of where she will live if she's working. The defense has stated that she has mental health issues and she wants to address those. But I don't know what the plan is for that, or if she was doing it before. She admitted that she was offered medications when this occurred. They say that she has suffered while in jail, but don't say how or provide any support for that. And I understand what Mr. Carn's agreement was, but unfortunately that didn't go through for whatever reason. So I'm going to ask the court to continue bond as is. Thank you.
Ms. Carey, do you know, is there a juvenile record? Because in my mind, I thought there would have been, but yet nothing shows in lien. So,
Judge, I'm sorry, I do not have her lien file, so I can't answer that. I know she was in the system. I don't know if she had consent calendar, but there were files with her in that court.
all right. Anything else, counsel?
Your Honor, the prosecution mentioned that there was not a plan allocated. I'd like to mention that she has a therapist just in general. She's also seeing a PTSD therapist. And she does have support. I don't recall if you remember back to the probation violation hearing, but there was someone here who was, would have been willing to allow her to stay with her. Above that, I do want to mention that Ms. Jones is in high school still and is attempting to finish that and is incredibly behind on the summer semester. I don't have anything else to add at this point. I would, if the court would, Ms. Jones would like to make a statement at some point.
Are you comfortable with that?
Yeah, I'm not that.
Ms. Jones, I'm going to caution you about saying anything about the case. I don't want you to say anything about the case or the allegations, okay? I'll also remind you that you have protections under your other case, so I don't want you to talk about that one either, okay? What is it you'd like me to know?
That the jail does not help me, my mental health. I have had multiple episodes in there, and I've already hurt myself multiple times in there. They don't help me whatsoever, and I really need my outside help. Like my regular therapist, my intensive therapy. I was supposed to get me medication. I'm very behind on school. I wanted to get a good job, get a car, finish my schooling, and go to college. I learned my lesson with that. Like, I don't.
Your what, I'm sorry?
I learned my lesson. I don't want to end up in the jail. Talk to all the girls in there. I don't want to end up like them. I'm not even from here. Just got dropped off here.
But you've been here for quite a while.
I mean, yeah, I have a new adopted family on Master Street. But when I was 15 or 16, my dad just dropped me off at a pizza place here. And the school has failed me here, so I'm now doing yours and online school. But I can only do that at home. I think I can't do it in the jail. I know I'm 19, but I'm behind, a couple years behind, and I would like to catch up and live peacefully and happily and get a better chance at life. I don't want to end up with people here.
Well, Ms. Jones, since this is a bond motion, we'll go through the requirements of bond. And some of the things the court is to look at pursuant to MCR 6.106 is the defendant's prior criminal record, including juvenile offenses. As we've already discussed, there is no official record regarding juvenile offenses. Record of appearance or non-appearance at court proceedings or flight to avoid prosecution. I've not had anything in that regard. A history of substance abuse or addiction, nothing's been presented to the court. Mental health, including character and reputation mental condition, including character, reputation for dangerousness. So what I do have is a case that the defendant's on probation for, in which it was alleged that she beat up a 14-year-old girl for statements made about somebody else's deceased mother. Then I have the seriousness of the offense, the presence of any absence of threats or possibility of conviction or likely sentence. At least the defendant is charged with a felonious assault, which is a 4-year felony. Now, I do realize that there's a possibility of a self-defense claim, but what the court is left with is only hearing one side of the story, so to speak. I do remember in the probation violation file reading a police report and not finding there enough evidence for a probation violation. But again, that was more so because no witnesses had been presented to the court to offset a self-defense claim. If we have a preliminary examination, I suspect there will be witnesses that will testify, and I'm suspecting likely would testify that there wasn't a self-defense claim. Employment status, the defendant was in between jobs at the time that this case had picked up. Obviously has not been able to get a job since. Responsible members of the community vouch and monitor for the defendant. I do remember other persons here in the multiple times that we've been here in the past. I don't believe they're here today. But what does stand out is at least the address that you gave me on Mauser Street is the address that you gave me at the time of arraignment and was the address at the time that these charges arose. Defendant's ties to the community, while her ties to the community are rather transient, meaning she doesn't necessarily, at least in the past, have a stable tie to the community. I do realize she has had ties to the community for quite a while. And any other facts or risks, non-appearance, danger to the public, etc. It is the that one that the court has some concerns with. As I had said, you were on probation in another case, and the allegations of that case have already stated what they are. And now, if I recall correctly, it was about a month later, you've picked up the new charge and elevated from an assault to assault with a dangerous weapon or felonious assault. It does appear that the defendant, at least allegedly, has a violent streak in her. And so I do find that she is a risk to the public. But I also do realize that there is a potential for based on what I've read the police report and as outlined by Ms. Jones today, while trying to take the plea, there could possibly be a defense. I'm not saying that there is, I'm just saying that there possibly could be. Bond was set previously at $10,000 cash assurity because I did find her a threat. I'd also ordered there be no contact with the victim in this case, Austin Elkins. I do realize that in the state that Ms. Jones finds herself in is the court ordering any bond is essentially a revocation of bond. However, I do find that she is still a threat. She went to somebody's house, at least allegedly, to get her earphones and wound up throwing a metal object at that person. I am going to reduce bond to a $5,000 cash surety with the same conditions. But I do believe there is an additional co-defendant that I was not aware of at the time that this arraignment had taken place. So I am going to add another condition that the defendant not have any contact with, what's the first name? With
Your Honor, if I may, I do apologize, just so the court's aware, that is the gentleman who's here for moral support.
I'm aware of that, but he's also a co-defendant in the case.
Yes, Your Honor.
So I'm going to order that there be a no contact with an Ethan McPherson as well. All other conditions remain. I will say this, counsel, if you're able to give me proof of doctor's appointments, proof that there's ongoing counseling, proof of medication, I'm not going to foreclose not hearing this again. But based as what's been presented to me today, that's where we're at. Okay? Anything else, Ms. Carey?
No, thank you.
Ms. Ejimera?
No, thank you, Your Honor.